Okay, we're being live streamed, but I'm ready to start the webinar if you all are.
Mm-hmm.
Here we go.
Okay.
It usually takes people a second to get back in.
Okay.
So we might wait. You might just tell people about the Zoom thing and about the webinar and say, we'll wait a moment.
Good evening, everyone. We're trying to get our webinar set up, so give us just a couple minutes until people get on board. Okay, I think we will go ahead and start if that's okay with everyone who are our panelists. Good evening. I'm the Reverend Jane Borum, NOAA's Criminal Justice Task Force co-chair. NOAA stands for Nashville Organized for Action and Hope. The Criminal Justice Task Force's mission is to organize and take actions for a more humane, safe, equitable, responsive, and restorative system of justice in Nashville. These activities occur through a lens of addressing systemic racism. On behalf of NOAA, we welcome our General Sessions Court incumbent judge, Lynda Jones. We also welcome her challenger candidate for judge in Division 9 in the person of Brian Horowitz. This evening, our forum will be moderated by the legal redress chair of the Nashville NAACP, attorney Courtney Teasley. Our timekeeper tonight is Erwin Vennick, member of NOAA's Criminal Justice Task Force's Cash Bail Reform Committee. He will let our candidates know when their allotted 2 minutes for answering each question ends. He will verbally announce a 30-second warning and time's up, and to the candidate's answer. Audience participants, that's you the viewers, may ask questions of our candidates in the chat room. The questions will be screened and read by Courtney Teasley, our moderator. We may not have time for all your questions. Also, by Tennessee law, we are not able to respond to questions regarding judges' past case handlings or appeals. If you have a specific question or a specific candidate, we would suggest you go to that candidate's website. Questions tonight need to be of a general nature so that all candidates can equally address the same questions. And as a reminder, this is a webinar-based forum, not a Zoom, so only the panelists are visually shown. Courtney, you can take it from here. You're on mute.
Thank you, Jane. All right. So we are going to get started here, and I would like to invite each of you to take up to 2 minutes to just introduce yourselves to everyone. And we'll start with the current sitting judge, Judge Lynda Jones.
Good evening. Thank you to NOAA for allowing me to be here. I really appreciate the work that you do in the community, and my church, Weston United Methodist Church, has been pretty active in NOAA for a long time. I am currently the incumbent. I have served my first term. My name is Lynda Jones, and many of you already know that I became interested in pursuing the law while in a mock trial competition in Bristol, Tennessee, East Tennessee, where I attended high school. I went to public school, and my high school teacher introduced us to the world of mock trial, and I fell in love with the law and decided to pursue law as a career. Since I've been on the bench, I have ruffled feathers a little bit. I bring new programs and innovative ideas to the bench. I introduced an anti-violence program the first year that I was on the bench with the Friendship House to try to coach people through who had been experiencing assault, and we try to what I did, the reason I bring these programs to the court system and try to introduce them is because I am asked to by constituents and by people in the community. And as a public servant, I feel it's my duty to introduce them. Now, they may not stay, they may not exist too long, but I feel it's incumbent upon me to at least listen to the people and try to introduce solutions. And there's a fine line between introducing solutions and being an activist. So I tend to just facilitate when asked. We have also collaborated and launched a shelter court, which serves as a problem-solving court to try to introduce
30
solutions
seconds.
for those experiencing homelessness. Thank you.
You have
Thank
more,
you.
30 seconds.
I'm sorry, what?
30 seconds. You have more
I'm
time.
sorry. I'm sorry. I thought you said 3 seconds.
No.
So in any event, I served as the president of our statewide judges conference. I'm very comfortable with all of my colleagues across the state of Tennessee. They have a great deal of faith in me. I was the presiding judge during the COVID crisis that we experienced in 2020. And while I'm mentioning the State Judges Association, we did also recently lose Mike Carter, who's been a friend of mine for over 5 years. I sat special for Mike on the bench up in Sumner County while he underwent surgeries.
Now we have
And
time.
it's an unfortunate loss, but thank you.
Judge. Mr. Horowitz.
Hi, I'm a Southern Jewish geriatric millennial who wears this green jacket every single time I appear in court. My name is Brian Horowitz, and I'm a criminal defense attorney. My father was in one of the first integrated classes at Meharry back in the 1960s, and my mother went to David Lipscomb High School. I may be the only Lipscomb-Meharry combo here in town, and I like to say that I'm more Nashville than hot chicken. I grew up walking the halls of Hickory Hollow Mall. I live in West Nashville, and I want people to know that I think independently and that people matter. And as a criminal defense attorney, it is important to me that everybody is heard and that everybody is listened to. I went to Nashville School of Law at night, and that taught me how to work hard during the day and also how to work hard at night. I'm not afraid of having 2 jobs, 3 jobs, 4 jobs, because I understand what it takes to make it in this world. I understand that many of the people that will come before me are working 2, 3, and 4 jobs, and that we need to make a better court that will provide assistance to them and that will provide accommodations to them, because people need help right now.
30 seconds.
Inflation has hit over 9%, and we need to do things better. Everything is fines and fees, jail time, fines and fees, and we have to come up with better solutions to help people right now. I'm running. I became a lawyer because I wanted to help people, and that was the best way I knew how to do. So that's why I'm a criminal defense attorney. I've done over 600 cases in the last couple of years, and I'm tired of complaining.
Time.
I'm running for office because I want to do something about it.
Thank you so much, Mr. Horowitz. We appreciate you. So I want to just give both candidates just a heads up. The first time that you hear from Erwin, that means you have 30 seconds left. So if you hear him say something, if you can't really hear him, don't let that mess up your train of thought, okay? Go ahead and continue pressing, because the first time you hear him, you have a whole 30 seconds left. Now, the second time you hear him, you have time. And I'm not being rude, but we have to get through all of these questions. So I have to go ahead and cut you on off, okay? No matter if you're not done. So I apologize in advance, but we gotta wrap it up. Okay. Now we will start with the first question, and we'll start with you, Judge Jones. You'll be answering this first. As a sitting judge, you will dispense justice through your judicial values and lens. What is your judicial philosophy with respect to accountability and punishment on the one hand, and rehabilitation and restoration on the other?
Well, every action has a consequence. And so I think as a parent, one of the things we all learn is that you have to teach your own children that for every action, there's a consequence. Some are good consequences and some are negative consequences. And so some of these folks in the criminal justice system never had the opportunity of parenting and guardrails and guidance to show them right from wrong, or they've grown up in such abject poverty that, everything's a little bit dysfunctional. Life is very different when you're living on the streets. So I think it's up to us as judges to guide people in the correct direction. And I've learned over time that sometimes gentle correction goes down easier and makes more of an impact than a harsh correction. When I was an attorney, I practiced in several surrounding counties, some of which had very harsh penalties. And Davidson County does things a little bit differently. We have the luxury of resources in Davidson County where we can assist people. If they're struggling with mental illness, we can make referrals. If they're struggling with homelessness, we can make referrals. If they're struggling with alcohol or drug addiction, we can give them some support. But at the end of the day, they are still held accountable for their actions. There are still consequences for every action. And I don't think the criminal justice as a whole intends to be entirely
30
punitive.
seconds.
I think what we're trying to do is be more nuanced in our approach. Every case is adjudicated individually, and there are times when lawyers might reach an agreement that doesn't make sense when you look at it on the surface, but the judge is supposed to review everything, make sure there's no mistake by the clerk, no mistake by the attorneys. Things happen. It's a busy courtroom, but it's up to us to look over it and say, is this an appropriate, nuanced solution for this individual coming through the criminal justice system with his background, whether it's developmental delay, mental illness, addiction?
Thank you so much. Mr. Horowitz, same question.
I believe that accountability is paramount. I believe that people shall be held accountable for their actions. However, what accountability looks like can take many different forms. I believe in redemption and I believe in compassion. I believe that just because you've done something wrong doesn't make you a bad person. And oftentimes it's not that person that's doing the wrong deed. It's an addict inside that person that's doing the wrong deed. It's a demon inside somebody that's doing the wrong deed. It's an outside influence on that person's life that's causing that bad deed. And that's why I think that it's important, especially in general sessions court, where it is the people's court. It is that initial introduction to the court system that most people have if you have a run-in with the court system itself. And so in general sessions, we have to slow down. We have to listen. We can't just look at the crime that was committed, but we have to peel back the layers of that onion and understand what's underneath it. We need to better utilize our resources. We need to do a better job of getting grants from the state. We need to do a better job of increasing our recovery courts. We need to do a better job of offering alternatives to traditional solutions, because in today's day and age,
30 seconds.
the traditional solutions are not working. I'm not saying we should be soft, but I'm saying that we have to look at different ways in order to hold people accountable than just jail, fines, probation. Jail, fines, probation. There's a better way to do it. And I would like to usher in a new form of justice in Nashville.
Time.
Thank you, Mr. Horowitz. Now, and also just for your information, Mike puts the question in the chat. So that way, if it's not your turn yet, you may forget what that question was, you can consult the chat and see some of these questions are going to get kind of long. So look in the chat if you miss portions of it. Now, we're going to come upon a lightning round of questions, okay? And so in this lightning round of questions, all you're going to do is tell us whether you agree or disagree with that statement. Now, if you agree, you don't say anything further, okay? You just say, I agree. If you disagree, you only have 15 seconds to give a very short explanation on why you disagree. Okay, so this is very, very fast, very short. So we'll start first, and Brian, you will go first on this one. First lightning round question. Your answer is agree or disagree. Disagree with 15 seconds only, okay? General Sessions Court judge campaigns should refuse contributions from the bail bond industry. Agree or disagree, Brian?
Agree.
Judge Jones.
I agree.
And I apologize, Mr. Horowitz. 2,
I can't remember.
General Sessions Court judges should support court watch programs through which the public can sit in courtrooms to observe how courts function. Do you agree or disagree, Judge Jones?
I agree.
Mr. Horowitz?
I agree.
All right. General Sessions Court judges should ensure that appointed counsel have the time, competence, and resources necessary to provide unbiased and zealous representation and monitor communications with the defendant they are representing. Agree or disagree, Judge Jones?
I agree.
Mr. Horowitz?
Does that question say that the judge should monitor communications with the defendant that the attorney is having with their defendant?
Says that they should monitor communications with the defendant they are representing.
I do not believe that judges should monitor the conversations that attorneys are having with their defendants. I think that is a breach of confidentiality.
All right. 4, General Sessions Court judges should waive fines and court costs when an indigent convicted person is seeking restoration of voting rights. Mr. Horowitz, do you agree or disagree?
I agree.
Judge Jones?
I agree.
Finally, we believe that 8 years is too long a term without periodic public engagement. Will you agree to participate in an annual meeting with NOAA and its community partners to review issues related to criminal justice and discuss the progress you have made to address your campaign concerns and promises? Judge Jones, do you agree or disagree?
I agree 1000%.
Mr. Horowitz?
Absolutely.
Thank you. That is the end of our lightning round. All right, next question. We will start with you, Judge Jones, on this question. There's a public perception that the current bail system and pretrial detention is unfair and primarily burdens people in financial need and people of color, and it's often excessive. Do you agree with this assessment? If so, what, if anything, can you as a General Sessions Court judge do about it? What's your position on bail reform? What factors should judges take into account when making a decision about a defendant's pretrial status? Judge Jones?
I agree that the pretrial detention system and current bail system is unfair. We have constantly been working on the bail system across the state of Tennessee, especially in Davidson County. I believe that anybody with a misdemeanor should not be posting bond unless they are, number 1, a flight risk, or number 2, exceptionally violent, and have a regular record of failing to appear in court. We need people to be in court. And if they are a violent, dangerous person, then I think a bond may be appropriate. As a General Sessions Court judge, we can do things about it. We can let people go on ROR. We can assign people to pretrial release. What I've done as a former president of the Statewide Judges Conference is led a bail reform effort, not just in Davidson County, but across the state of Tennessee. I've been educating magistrates, court clerks who do not have a law degree, who set bonds when General Sessions rural judges are not in the office, because some of those General Sessions judges, some of my good colleagues, are only in court 2 or 3 days a week. And it's a monumental task. You would think you would just ask to go present to the magistrates, but they don't want you to come and present. You would think that you could just go to the court clerks and make a presentation, but guess what? Some of those court clerks don't attend those conferences, and they don't want a judge coming in telling them how to set the bail. So it's a constant process. I started this process 2 years ago. It's going to take me at least another 2 years to complete it, and I need the cooperation of the Clerks Association and the Magistrates Association. It is something that you kind of have to continue to push. And as many of you who know me, I'm a little resilient and I have a little grit and I keep pushing. So I keep trying to educate not just Davidson County, because I have wonderful colleagues in Davidson County, but I'm trying to reach all 95 counties, all their magistrates, all their court clerks who set bail when there is not a judge available.
Thank you, Judge Jones. Mr. Horowitz, same question.
I'm sorry, there was can y'all hear me? That my screen just showed something strange from the host.
Yes, we can hear you. And
Okay.
so this question right here is about the bail. So
Yes.
you got that? Okay.
Yeah, it was a strange thing for the mute. So I apologize, but I had to click off of it. No, I absolutely believe that the current bail system disproportionately affects people of color and people who are subject to poverty. It's as sitting judge, if I were to be elected, the biggest thing that I've run into is that oftentimes, if you make an oral motion to amend the bail, the judge can say, well, the statute requires that it be written, and the state can argue against your motion. As a sitting judge, if you cannot make bond by your initial appearance and you are sitting in jail, first of all, I think that it is imperative that you get that person an attorney. Secondly, I think that it is imperative that you go through the bond factors and that you truly listen to each factor, and that you pay attention to the most important one, which is the fact that bond was created in order to give you an incentive to show back up to court. Far too often, we have excessive bonds that for an individual who has never missed a court date. That individual may have a record, but if they're always in court, that is what bond is for. Now, if you are a menace, if you have been charged with a violent crime, and the likelihood of conviction for that violent crime
30 seconds
is high, then you may have to address the bond and you may not want to amend it. However, far too often we have people of nonviolent crimes that are held longer than necessary simply because they are poor and simply because they cannot come up with a couple $100. And I think that that's terrible, because being poor should not be a crime, and it currently is in our justice system.
Thank you, Mr. Horowitz. Now, this question is yours to begin with. The next question is, a recent federal court decision ruled that the Constitution requires a timely bail hearing at which a defendant is represented by counsel. Do you believe that the current practice of conducting bond hearings in general sessions court complies with the constitutional requirements? If not, how would you remedy bail hearing practice in general sessions court?
So I've had over 600 indigent cases in the last 2.5 years as a criminal defense attorney. I have done numerous bond hearings over the last year, but primarily over the last 6 months, because of that ruling and because judges are making sure that defendants have counsel. And I think that that is imperative, because if you are a participant in the court system, it is imperative that you know your rights. Your rights do not end once you've been charged with a crime. Your rights do not end once you go to jail. Your rights do not end once you appear in court. Your rights should be always protected. And the best way to protect those rights is to make sure that those individuals have counsel. So on that initial appearance from jail, I will make sure no matter what, as long as they qualify under the law, that they have counsel, and that counsel has to be competent. So you can't just give them anybody. You have to give them competent counsel in order to fight for their rights.
Thank you, Mr. Horowitz. Same question, Judge Jones.
This is a great question. This is an issue we've actually been working on for about 5 years. That federal court decision is the Hamilton County case out of the Eastern District of Tennessee, which was actually a good ruling that needed to be done in order to straighten out practices in several other rural counties. It requires a bond hearing. They generally recommend within 48 hours, and we've tried a couple of different solutions. We have asked the public defender to station an attorney down at our night court when people are arrested. Our district attorney actually posted a prosecutor there at night court for 30 days, and no one was supplied on the defense side. So I've said, bring me, people within 24 hours, we can turn them around that quickly and have bond hearings. The public defender, because of staffing issues, asked for 48 hours. So we offer hearings within 48 hours. Prior to that Hamilton County case, I was asking on every jail docket in 3A and 3C, which is our felony jail and misdemeanor jail, I would look at the public defender and say, do you want a bond hearing? And 9 times out of 10, they would say no. So I offer constantly, it's something I ask daily, do you want a bond hearing? Do you want a bond hearing? So I feel like we are within the guidelines of 48 hours as required, even though the Eastern District does not control us. We try to be innovative and we try to lead the way for the state of Tennessee. So I constantly offer bond hearings. And I see a second question. Okay, I see a question down here. It says, on what grounds would I deny a bail, revoke a bail, or set a bail? The district attorney brings motions to revoke bail if people commit new arrest while they're out on bail for a first offense. And we cannot set bail impossible to make. We have to give people a reasonable amount of bail. And deny bail, never. I see no grounds to deny bail. I think that's unconstitutional. Everyone must be allowed the opportunity to post a reasonable bail.
Thank you so much, Judge. Now, we're gonna go ahead and actually, we don't have very many questions in there at this moment. And so I'm gonna go on with a few more questions before we take audience questions, if that's okay, Jane. You fine with that? Okay, awesome. All right, we'll continue on. Now, the next question is going to be for Judge Jones. You'll start. While holding persons convicted of crime accountable for their actions, we are interested in sentencing practices that will help those who have committed crimes learn from their actions and become better citizens. What is your definition of restorative practices? Which restorative practices do you believe are the most impactful? Are you committed to using restorative practices in your courtroom?
Yes, I would.
Oh, and I'm sorry, Judge, one last question. How have you used restorative practices in your courtroom?
So I have welcomed, like I said, the Anti-Violence Project, which had a restorative bent to it. I've also had meetings with our district attorney and our public defender, inviting them to have restorative justice circles. There are a couple of groups in Nashville that do that. Raphi Institute is already doing that in juvenile court. And then Gideon's Army is also interested in doing that. But that next step has not taken place yet. There needs to be data collection on the cases that we put in there. And so I have to wait. I have to have the district attorney and the public defender agree that they will put cases through there. We've had discussions about starting with auto theft cases and then building from there, but I am very open to it. I welcome it. I'm ready to start next week if the DA and the PD want to go ahead and have a circle run by Raphi Institute or Gideon's Army, and in trying to restore people, because people have different responses. I've noticed like the victims in some crimes don't want to get a pound of flesh out of the defendant. I've seen a man who's had things stolen from him weeks after his wife died say, no, I'm not worried about it. I want this young man to get on the right path. But I've seen some people who are over the top and angry, and they need a lot of healing, and there needs to be something that makes them whole. So I'm very open to it. I welcome it, but I can't do it by myself. I've got to have the district attorney and the public defender involved in that.
I'm sorry, Erwin. I didn't hear if that was 30 seconds or time.
That was.
Okay, thank you. Brian, Mr. Horowitz, the same question. However, your last question will be, how would you use restorative practices in your courtroom?
So I sit on the board of Benton Hall Academy. It's a small school for children who learn differently in Davidson County. There's a 6-to-1 student to teacher ratio, and all the children who attend that school and graduate get a traditional diploma. And that's important to me because I had to go to that school for 2 years to learn how to learn. And not everybody knows how to learn. Not everybody knows right from wrong. Not everybody knows that the greater impact of what they do. And so it's incredibly important that we focus on individuals and that we give them a path to success, just like Benton Hall does, that they can get to that finish line and they can get to it and be proud of what they've done. I don't think that it's just the judge, the district attorney, and the defense bar. I think it's important that we have a lot more community buy-in, and that's not just from nonprofit organizations, but for-profit companies that have jobs, that have opportunities. Because if you're an addict, if we can get you into a recovery court and we can get you off of those drugs, that's just step one. Now we need to get you job trained. Once you've been job trained, now you can earn and take care of yourself. But if you're in a halfway house, you're paying your own rent instead of Davidson County paying for you to be incarcerated. Once you can take care of yourself, you can take care of your family. Once you can take care of your family, you can take care of the community. So we have to restore people, because by restoring people, we bring families back together and we make a stronger community.
Thank you. All right, this next question, we will start with you, Brian. Mr. Horowitz. In recent years, many of us have become more aware that implicit or unconscious bias can lead to discriminatory behavior, and that implicit or unconscious bias leads to discriminatory practices and outcomes in the courtroom. What do you do to defend against implicit bias creeping into your own behavior and action in the courtroom? And how would you address the biases of others that you observe in the General Sessions courtroom?
So I try to fight implicit bias every day. We can talk about gender bias. I have a female campaign team because politics have been controlled by men for so long. If you want to talk about LGBTQIA plus bias, I have pride signs all over Nashville because I believe everybody should be represented in this race. If you want to talk about age bias, I made my campaign manager, she's a 24-year-old female. I've had age bias used against me when people say, well, look at experience and look at this. It's saying that I'm too young. Well, I have the experience and and while I may be 37 years old, I have the experience and I have the ability to do a great job on the bench. I think you need to surround yourself with people who are not like you. I think you need to use imagery, and I think that you need to pay attention to your surroundings. And I think that you have to, like when you do docket call, I think that it's a problem if when people are answering and the district attorney can see that person, there may be an implicit bias that district attorney automatically has against that person due to what they're wearing or how they answered. I've seen judges get upset with defendants because of the
30 seconds.
language that they use. And that language may be proper in their community and not in the courthouse. And we have to educate people, and we have to not hold it against them that they didn't come from the same place as we do. And we have to fight against implicit biases every day. And I try to do that as a criminal defense attorney. I do everything I can to treat everybody with dignity and respect.
Thank you, Mr. Horowitz. Judge Jones, same question.
So thank you for the question. It's an important question. I think it's incumbent upon all judges, all elected officials, and anyone involved in the criminal justice system to defend and educate against implicit bias. We're all born with implicit bias. We know the people who look like us and act like us and come from the same socioeconomic background, but we cannot hold other people who are from different backgrounds to the same standards that we may have grown up in. It's incumbent upon us to understand poverty, to understand racial bias, to read books, to get into things, read American Prison, read Dying of Whiteness, attend CLE. We have judicial CLE. I'm very active in 2 National Judges Association as well as the statewide judges conference. And I go above and beyond with CLE. We're required to have 15 hours a year. I usually take 30 to 40 hours a year. And I voluntarily take implicit bias training, even though state of Tennessee does not require it, because I think it's that important. The more you do this and the more people you're exposed to and the more of an open heart that you have to people who are different from you, the more you understand. Some of us were born very fortunate. I was born to a poor family. However, I was given some privilege because of the color of my skin. So I feel very connected to people who may have dropped out of high school, only attended high school. I was the first person in my family to go to college. When I was in high school, I held 3 jobs while I was going to high school and college because that's what it took. So I represented thousands of people who went through bankruptcy, who lost a job or had a medical condition and had no insurance. I routinely go and speak in the community. I speak, I've attended Interdenominational Ministers Fellowship. I go to public schools and talk to kids. And I do a lot of listening to a lot of different communities and blessed to have friends in a lot of different communities. So
Thank you so much, Judge Jones. This question will start with you, Judge Jones. There is concern about the incarceration of nonviolent offenders. Nonviolent offenders have been sentenced to spend decades in prison. The collateral damage to families, children, communities, it has been profound. At the same time, some in the public expect judges to adopt a tough on crime approach. Do you think that this is an issue? If so, what would you do about it as a General Sessions Court judge? Are you concerned? Oh, I'm sorry, one last question on there. Are you concerned about being accused of being soft on crime?
I'm not accused about being soft on crime because I've been accused of being soft on crime. So I think there is an education component that's important here. There's a huge difference in General Sessions judges who only have the power to incarcerate someone for up to 11 months and 29 days. The decades in prison happens at the criminal court level. That is the criminal circuit court judge's purview. General Sessions judges do not sentence people to spend decades in prison. I believe that the collateral damage to families, children, and communities is profound just at the General Sessions Court level, because if you put a man or a woman in jail for 3 days, they're going to lose their job. And I don't even think, we have to be very, very careful before we even put someone in jail for 3 days. When I was elected 8 years ago, it was still the practice of judges who are now retired to put people in jail for 10 days on a driver's license offense. That causes a ripple effect that is unbelievable and embarrassing, and we should not do it as a civilized nation. So I start accepting lesser pleas, and I was stopped in the hallway and people would say, it's mandatory 10 days in jail. And I would say, well, not today. not in Division 9. Judge Jones is not going to toss somebody in 10 days in jail for not having a driver's license. So I focus on those misdemeanors that are under 11 months and 29 days and do what I can there. I cannot control the criminal court judges above me who sentence people to decades in prison. That is something that it's going to take a collective society effort. It's going to take a collective community effort to go to the legislature and pass different laws about incarceration for people for felony cases and for multiple offenses. It's going to take a change of our current structure of our sentencing system. And as you know, that is a heavy load to lift, but you have numbers in NOAA and the community has numbers. And if the community speaks loudly enough, the legislature has to pay attention.
Time.
Thank you. Mr. Horowitz, same question.
I've often been asked about, am I, being soft on crime? Because I'm a criminal defense attorney. So the number one goal when I go into any courtroom is to make this problem go away. Now, as if you talk to any criminal defense attorney, you know that that is rarely the case. And so now you are just looking for the best possible outcome. But in general sessions court, the only time you would have a felony is if it starts there, and the most you can do with a felony is have a preliminary hearing. So I agree with Judge Jones, and it's not something to agree or disagree on, that we are dealing with 0 to 11 months and 29 days in jail. Any period of time you spend in jail is far more punitive to an hourly worker than it is a salaried worker. It's far more punitive to somebody in a lower ranked position than a higher ranked position. And your people in poverty are often in those positions where if they miss a day, 2 days, 3 days, they're going to lose their job. Once you lose your job, you lose your house because you don't have the money to pay your rent. Once you lose your house, everything falls apart. Your family could fall apart. You could lose your children. And now, without a job and without a house, now you can't pay your costs and your fines. And then
30 seconds.
You could potentially lose your driver's license. So it's incredibly important that we focus on non-incarceration programs that rehabilitate and that actually focus on the reasons why people are doing things. You don't just you're not just saying, oh, don't worry about it, see you later, but you actually get them into programs that can help them. And for that, we need more money from the state, and it's actually money better spent.
Thank you so much. The next question. Do you agree that all attorneys, the victim and defendant, and all witnesses should be treated with respect and dignity? We will start with Mr. Horowitz, and the question further for you is going to be, how would you preside over your court consistent with your response?
So I think that victims are paramount to the process and paramount to the process working. Many people don't understand when they say, I don't want to press charges, that it's the state of Tennessee versus my client. It's not victim versus my client. However, the victim should have a voice in what happens. If you have a theft victim who wants that person to get help, then I think the court should listen. If you have an assault victim that wants that person to get help, the court should listen. If you have an assault victim that wants a more punitive approach, then the court also needs to listen to that, but also take into account everything that they have at their disposal. And sometimes it's imperative that the system educate victims on what is happening and what these programs are, so they better understand the reason why we're putting individuals in these systems, in these programs. Now, when it comes to attorneys, you have to treat attorneys with dignity and respect. And sometimes judges don't. And one of the biggest reasons, or one of the biggest examples, is when a judge does not accept a deal that has been put together by the state and the defense bar. It's happened often, and every single time that's happened to me, it's because the penalty was not harsh enough. And I've never had a judge say that this penalty is too harsh and we're going to make it lighter. We have to respect the process, and judges shall not legislate from the bench. And if the state and the defense bar agree to something, judges need to honor that and not be so afraid to do the right thing.
Thank you, Mr. Horowitz. Judge Jones, same question. However, yours is, how have you presided over your court consistent with your response?
So I can tell you this, when you start on the bench in year one, even up to the first few years, you're a little bit different by the time you get to year 6 and year 8. So you, as experienced as an attorney may be, and as thousands of people they may have represented, when they get on the bench, it still changes. You feel like the way you can explain or understand the General Sessions Court system because of the huge volume that happens is if you're leaning over and you think you're going to take a small sip out of a water fountain, but then you turn the water on and it's a fire hydrant. And so it takes a little bit of adjustment time to get used to everything that's coming at you. You have a lot of emotions, you have victims' rights, you have deputies you're dealing with, you have attorneys, you have some disrespectful attorneys and some respectful attorneys. All of that takes a little bit of time to get used to. Over time, it becomes easier, it becomes gentler, things impact you. So I can tell you now that having been on the bench, I treat people with more dignity and more respect than I did from day one. Although, you know, at the time I was so sensitive to racial issues and poverty that I know I was being respectful and treating people with dignity. Now, there are going to be people that dispute that. There are going to be attorneys who lost their cases. There are going to be attorneys who filed bad motions or maybe didn't do an effective, thorough job with their clients. Those attorneys might be upset with me. They might be upset with my colleagues. My opponent seems to be addressing the way some judges in the cases that all the hundreds of cases he's done in Sumner County really aren't the way cases are handled in Davidson County. So I'm sorry that he's had that experience up there in those cases.
I'm sorry, Judge Jones. Thank you. Now, we are going to go to the next question. The next question is, so there is concern among some that judges assess the credibility of police differently than the defendant and defense witnesses. How would you assess the credibility of police, the defendant and defense witnesses? Judge Jones, this is your question first.
Police are human. They have implicit bias. And the more you listen to cases on the bench, the more you realize there are some officers who always regurgitate bad answers, like they always smell the obvious odor of marijuana. It's almost like they memorize the language out of a textbook. So over time, you hear these cases and you realize this is ridiculous. This is a pretense. There are some officers that will out and out lie. And I'd like to be benevolent and think those officers don't know they're lying. Some of them might because they think the ends justify the means. They think they're removing the bad guy. But I'll be honest, I call officers out if I think they're not being forthright. I've had bench trials where I've dismissed cases against African-American men because I think the white military background officer was making a biased opinion and wasn't looking at the evidence. Our job is to look at the evidence. I presided over the Justin Jones trial and dismissed the charges against him because I didn't think the trooper who was testifying was credible against him. So I dismissed the case against Justin Jones. So I think we can't give officers more credibility. They're just humans. And we can't give, I mean, everybody, I'd like to assume they're honest, but my experience tells me people are human, people make mistakes, and sometimes people just lie.
Thank you, Judge. Mr. Horowitz, you have that same question.
So I understand that not all stops are created equally. I understand that some groups, some automobiles, some parts of town are more targeted than others. I think that when you're on the bench, you have to pay attention to that. You have to pay attention. Was it a tag light violation? Was it a tent law violation? Was it pay attention to the stops that are clearly fishing expeditions. I love fishing, but not when it's an officer stopping somebody and then saying, oh, I smell marijuana, and now they can just search and search. One of the biggest frustrating things to me as a criminal defense attorney is when an officer says, well, I smelled marijuana, and the case is a simple possession for heroin, or the case is something completely different than the purpose, than A, the purpose of the stop, and B, the reason that the officer used for the search. What I would like to see is that specific case not even get to me. What people don't understand is, as a judge, you do have discretion, but one of the tools that you also have is to demonstrate to both the state and the defense bar is that you won't be a rubber stamp, and that I wish that our
30 seconds
attorneys would be stronger and would actually not take those cases forward. And I wouldn't even see them to begin with, because the district attorney's office has the ability to prevent that case from ever being in front of me. So I think that they're on task for weeding out those cases first. And then if they fail to do so, when it comes to me, I will look at that and I will take the time to truly understand what happened.
Thank you so much, Mr. Horowitz. Now we're going to take one audience question. It says, what have you done in the past year to improve the criminal justice system for the poor and people of color? Judge Jones?
In the past year, so I've emphasized implicit bias training. I initiated an equity, judicial equity collective group that consisted of representatives of the LGBTQ communities of color, Hispanic communities, Black communities, in order to provide training for our court staff, for our deputies, for our court clerks. We took a little bit of a break during COVID. We've just resumed again, and we're having that training so that we can help people see their implicit bias and help remove it.
Thank you. Mr. Horowitz, the question for you would be, what would you do in the first year to improve the criminal justice system for the poor and people of color?
So what I have done is I've done over 200 indigent cases. Indigent means if you cannot afford an attorney, one will be provided for you. And so I have taken time, because I know from what much is given, you have to give back. And so instead of taking market rate case after market rate case, I've devoted a very large percent of my practice to helping indigent individuals who cannot afford competent counsel. Now, what would I do? One of the things I would do initially is to lobby the state and lobby our legislature to increase the amount of money that indigent counsel gets paid on an hourly basis. That number is lagging. And I think that, as Judge Jones said, the district attorney put somebody at night court, but it's difficult to get other attorneys there. So therefore, we have to incentivize. We have to find that money. We have to give people a motivation, give attorneys, defense attorneys especially, motivation to take these indigent cases in order to give back. But they shouldn't be taking these cases at the sacrifice of their family, at the sacrifice of paying $5 gas, at the sacrifice of paying extremely high rent. They need to be paid a living wage. So what I would do is put a sign in front of my courtroom.
30 seconds.
If you cannot afford an attorney, ask us how we may provide one. And it's not just lip service. It's a giant sign in the courtroom that says, hey, one's available. And B, we will get a lot more if we paid indigent attorneys a living wage.
Thank you. Next audience question. I found another one. It says, on what grounds would you deny a bail, revoke a bail, or set the bail impossible to make? Mr. Horowitz, you start.
Well, I don't think it's appropriate to ever set a bail that is impossible to make. That is strictly punitive. Now, one of the questions was, when would you revoke a bail? I think that that's a very interesting question. In the latest report that the General Sessions Court put out, I believe it said that 41% of drug tests to probationers were positive. That doesn't mean that those 41% should have their should have their deal revoked. And it also doesn't mean that if you're out on bond and you come in and there's an issue, that you should immediately have anything revoked. If you commit a new nonviolent crime while out on bail, that should not automatically revoke your previous bail. However, if you continuously fail to show up to court, that is the purpose of a bail. So I do believe if you continuously FTA over and over and over again, then yes, your bail should be increased. And the last part of that bail, I can't read the question, so I don't know. But it was, when should it be revoked? When should it be set incredibly unreachable? And what was
Denied.
And when should it be denied? I don't believe that bail should be denied. I believe that it should, unless it is a absolute heinous act that was undeniably the act of a specific individual, and that person is an absolute
30 seconds.
detriment to the community, then you do need to set a bail incredibly high. Other than that, you need to give people a chance. You need to pay attention to why, again, to why. We have to start paying more attention to why, because our state does not allocate enough resources to the health department and to other programs
Time.
that benefit people.
Thank you so much, Mr. Horowitz. Judge Jones, same question.
Yes, I'm sorry. I thought I answered that question earlier. It's unconstitutional to set a bail too high for someone. And the only time I hear revocation of bond is when the state brings a motion to revoke a bond based upon a new charge. Those hearings have to be proven on a case-by-case basis. And I also want to reiterate something and clarify something I said earlier. I want to make sure that when we were talking about the 48-hour hearings for general sessions and bonds, that I want to be very clear that our public defender may be short-staffed. There is uneven budgeting between the district attorney and the public defender's office. So I don't want any of my remarks to be intended as disparaging the public defender's office, because I think we have the best public defender's office in the entire state of Tennessee. So they both do a fine job and are hardworking. They both battle it out in court daily. I believe setting a high bond is unconstitutional. We have to look at the likelihood of conviction, the danger to community, and the ability to afford. And again, I think misdemeanors should not have a bond unless there's a consistent failure to appear and violence and danger to public safety.
All right, thank you. A plea bargain is an agreement between the defendant and prosecutor in which the defendant agrees to plead guilty to some or all of the charges against them in exchange for a more lenient sentence and or an agreement to drop other charges. Some prosecutors may overcharge, others may threaten additional charges, and others may threaten a trial penalty if the defendant insists on going to trial. Research over the last 10 years has demonstrated that some defendants will plead to a lesser charge even when they are not guilty. What concerns do you have about plea bargaining? What can you do about the so-called trial penalty with respect to plea bargains? And would you inquire about the trial penalty when you're deciding whether or not to accept a plea agreement? Judge Jones?
So I see the trial penalties occurring more at the criminal circuit court level than at the general sessions level. I personally love bench trials and welcome as many bench trials as possible. I think some attorneys may be afraid to bring a bench trial because they don't know the judge well enough. And I have no concerns about plea bargaining whatsoever when it comes to the public defender's office. I do have concerns about appointed counsel. I wrote a 14-page booklet on what I expect appointed private counsel to do if the public defender has a conflict. I meet with attorneys in my office. I go over the 14-page booklet and I tell them, this is what I expect. I expect a thorough interview. I want to know everything about your client. I want to know if he has developmental delays. I want to know if he has a mental illness. Is there a job? Is there a family? Is he taking care of an elderly family member? I want to know everything about that defendant because I think it's important. And if I ever find out that an attorney who has been appointed a case is not doing thorough interviews, I will not appoint them to any other cases. I've met with community groups who have concerns. I've asked them, tell me who these lawyers are that you think are not doing a good job. And they're all upset with the criminal court judges, the higher court judges. They've never come back and brought a single name to me. So I still welcome any community member who thinks a private appointed attorney is not following the rules and doing a good,
30
zealous
seconds.
job, thorough job. I really want that information brought to me because I won't appoint them to represent someone in their life. Someone's individual liberty is at stake, and it's the most important trust that can be had. So we don't want attorneys who are rookies, who are inexperienced, who haven't even haven't attended a tactile meeting, haven't gone through the booklet, haven't had any kind of training. We don't want those rookies representing people because their lives are at stake.
Thank you, Judge Jones. Mr. Horowitz, same question.
So I think exercise is incredibly important. And I think exercising your rights is even more important. And I will never punish somebody for exercising their rights in my courtroom. One thing as a criminal defense attorney I have found is the laws are disproportionate to, and they target different segments of our society. If you have a bottle of Adderall, that's just a simple possession. But if you have 1/10 of a nickel, everybody knows what a nickel is in your pocket, 5 cents. 1/10 of that is a felonious amount of cocaine, of crack, of heroin. And so if you have 1 gram, which many addicts use on a daily basis, 1 gram is a felonious amount. And DAs will often say, well, I know that I can charge this as a felony because you have so much, but this is what I'm going to do for you if you'll take it down here. Now, that is a very difficult scenario for many of my clients because they may think the stop was bad. They may think the search was bad, but they can't afford a felony conviction. And so they'll take a misdemeanor charge simply because the risk is too high.
30 seconds.
So I do think that it's important that you ask, and if in a case that just doesn't, in cases, I think you should ask, what were your other alternatives? And also, I think that you need to do a great job of educating the defense bar and the district attorney's office, because while I love bench trials, we have to be allowed to have them, and the district attorney controls that. The defense bar cannot just say, I want a bench trial. It has to be agreed to.
Thank you, Mr. Horowitz. Judge Jones, final question. Please close your time with us explaining why we should support you rather than your opponent. What will you bring to the General Sessions Court bench that your opponent will not?
Well, I bring 8 years of experience. I bring the willingness to ruffle feathers and to try new programs and to do innovative things, to accept restorative practices and to create the shelter court and to try innovative new problem-solving measures. And I hope that those are successful. I believe I've collaborated and have experience with working with the district attorney, the public defender, the criminal court clerk, the sheriff's department, the mayor's office, the nonprofit stakeholders in the homelessness community, the recovery courts, the halfway houses. And I collaborate and have done that in the past and will continue to do that in the future. I bring education to the table. When I was a practicing attorney for 23 years, I worked on education and improving the bar. As a judge, I am in the education committees for 3 associations, state and 2 national, to continue to educate not only attorneys, court clerks, magistrates, but judges all across the country. I will continue to learn from other judges, such as Steve Mitchell, who runs a program for the homeless out in the Los Angeles area that's been successful over 20 years. And I will continue to look to other places for new ideas and try to innovate here in Nashville. Nashville leads the way in Tennessee. I'm very proud of the Nashville court system. I know we can do better. I know we can improve, and I constantly seek to improve not only everything in our criminal justice system, but to seek to improve myself as a judge as well.
Thank you. Mr. Horowitz, same question.
I think independently, and I put people first. I will serve with dignity and respect. I believe in compassion, and I believe in redemption. I think that the individuals who appear, whether it's on the civil side or the criminal side, I believe that they matter. I do not think that poverty should be a crime. I do not think that all stops are created equal. I do not believe that all witnesses should be treated the same. I do not believe that everybody tells the truth. I do not believe that just because you are a person of stature versus a person of an indigent individual, that I should believe one or the other. I am doing this because I want to help the community. I understand the privilege that I have been given, and that is why I'm trying to use that privilege in order to give back to my community, because I feel that it is imperative that we give back to our community. I think that it is imperative that we build our communities up. I think that it is imperative that we listen, and I think most importantly,
30 seconds.
that we should smile every once in a while. I think that everything is so hard right now that we need to take a step back, and we need to look at individuals, and we need to promote individuals, and we need to tell everybody that you matter, and that I will listen to you, and that I would love your vote on August 4th.
Thank you so much, Mr. Horowitz. Thank you to both candidates. I will pass it back to Ms. Jane.
Well, we want to thank each of you for attending the forum. We thank our candidates especially. We thank Courtney Teasley, our moderator, and you, the voters, for joining this evening's informative event. Tonight's forum has been recorded, so you can also find that on NOAA's Facebook page. All recent NOAA candidate forums are also stored there. Davidson County's primary election is Thursday, August 4th, next month. The general election is Tuesday, November 8th. Hear now what a former U.S. Congressman, John Lewis, who struggled his entire life for all of us to vote, once said, "The vote is precious. It is the most powerful, nonviolent tool we have in a democratic society, and we must use it." So thank you all for attending today's event. Have a safe and peaceful evening. Good night.